So the intention to create legal relations and the intention not to be legally bound, two important expressions of the will of the parties. The intention to create legal relations and the intention not to be legally bound are different. Italian legal system and in English legal system and United States legal system. In fact, according to the established principles of common law, there is no pre-contractual dimension and negotiation between the parties is free and aimed at the conclusion of the contract, and doesn't know the pre-contractual obligations that are imposed under Italian law. In addition, in common law systems, the parties' intention to create contractual relationship is a fundamental requirement for there to be a contract, and the lack of this statement will exclude the configurability of the contract, even if it fulfills its other structural elements and identifiers. The Italian system instead, the Italian legal system instead, is more problematic. Since, as is well known, in the pre-contractual stage, the parties are required to comply with the principle of good faith provisions of Article 1337 of the Italian Civil Code, and therefore may be incurred in pre-contractual liability if they contravene, if there is the violation of the obligations that derives from this principle. Therefore, the conclusion of a gentleman agreement or an agreement is not binding may expose the parties to the risk of attribution of liability and the obligation to pay compensation for damage caused during the negotiations. Which is the Italian case law known about gentleman's agreement. There is a first case decided by the Rome Tribunal in 1995. The case concerned the qualification to be awarded to a private agreement that the parties had called gentleman's agreement, and that they had equipped with multiple references to honor as well as the general conditions of fairness and good faith. The Court of Rome verified the presence of the conditions which constitute the essential elements of the contract and the financial content of the agreement, felt obliged to give greater importance to the objective fact of the relationship. It was so excluded in the availability of the parties the capacity to bind themselves only in terms of honor. A second case decided by Tribunal of Crotone, Court of Crotone, Court of First Instance, on 5th July 1999, say this: the express qualification of the agreement as gentleman's agreement leads to the conclusion that the parties have consciously intended to make a commitment not relevant in legal terms, but only in terms of honor, loyalty, and correctness, and therefore, as such, a commitment characterized by the absence of a legally binding force by law, enforceable and unsusceptible. According to the Court of Crotone, you can arrive at this conclusion on the basis of the lexical meaning of the above qualification, both in the original languaging, in current firmly established in the countries of origin, and then implemented by others. Indicates a figure, a kind of agreement or understanding other than the contract, characterized by being considered binding only in terms of honor, as concluded between persons who consider themselves particularly sensitive to the value of honor, and then brought to an extent greater than that of the other subsidiaries to recognize such agreements or arrangements efficacy, morally binding, but not for this, less intense. There is a last case decided by the Supreme Court, Italian Supreme Court, in 4 February 2009. In this case, the parties had qualified their agreement as a letter of intent, with the clear intention of avoiding the legal restriction and to consider it as a mere preparatory deed for a future contract. A simple initial deal for fixing terms, conditions before conclude the future contract. The Supreme Court confirmed that to locate the legal bound of an agreement plays a central role the will of the parties to consider concluding the contract. So it's irrelevant that there is a complete legal system of a partial bargaining structure when there is no intention to achieve the agreement, and in any case, follow the approach. Supreme Court followed the approach for which the nomen juris chosen by the parties is not relevant when the overall tenor of the contractual clauses and the behavior of the parties before and after the conclusion of the agreement can infer the binding nature of the relationships concluded by the parties.